الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وصحبه وسلم تسليما كثيرا. Alhamdulillah, we are continuing our lessons on Mukhasar Quduri, and we're in the chapter on Iddah. And we stopped after a brief lesson introducing Iddah at فإن عُتقت الأمة في عدتها, correct? Right? So we know there's a principle that الرفق منصف, right? That the state of slavery happens responsibilities and rights, right? So their iddah is half the iddah of the free woman. So how do you have three? How do you have three? Can you? No. Then how many is it? Two. Okay? Because you cannot say, okay, halfway through the hayd, right? So it goes to two, right? But what happens if she's free during her iddah? When she started, her iddah was two menstrual cycles. But now she's free, so he tells us, فَإِنْ عُتِقَتِ الْأَمَةُ فِي عِدَّتِهَا. If the slave woman is free during her iddah, مِنْ طَلَاقٍ رَجْعِي, from a revocable divorce, انتقلت عدتها. Okay? Her iddah transfers from the iddah of someone in slavehood إلى عدة الحرائر, to a full iddah. And this, of course, relates. There's a lot of background to this. One of the things is that in our madhab, ما يتعلق من الأحكام بالأوقات فيستند إلى آخرها. Those matters that relate to time in our madhab are ascribed to the ending of the time. A time or period. Similar issue happens. Let's say Sidi Hamza Khan has a friend named Hamza, so he got engaged, and he was walking home and he was so excited. He was walking back to his hotel room in Berlin, because he got engaged in Germany, and he walked into a wall, so he fainted. Okay. But now he's resident in Berlin. He was visiting a neighboring town, so he was when the time entered, he was a traveler. He hadn't prayed Asr yet. At the end of the time, he was resident. How many rak'ahs were due on him? Ascribed to the end of time. The end of the time. Right? And vice versa, right? If someone, Asr came in as a resident, but then one travels, and let's say, la samahallah, someone's in a car crash, and they fainted. What is obligatory upon them? What was due at the beginning of the time or the end of the time? Etc. So here, same thing applies, right? But the difference between the talaq al-raj'i and the talaq al-ba'in is the talaq al-raj'i, the nikah is so it's a state of talaq. So the iddah is going on, right? But it is being reversible. The halat al-zawjiyya, the state of marriage, like imagine this is a firm state of marriage, right? The talaq al-raj'i, right? The state of marriage is now in process of ending. So there's ahkam related to the iddah, which we'll be seeing, but the bond of marriage is still, there's still a rope connecting them, right? So he could say, come back, right? He brings her back, right? So that connection is still there, right? although it's a state of divorce, right? But that's the sense of it being revocable. As opposed to talaq al-ba'in, right? Which is case B, which is this state also is a state of iddah. So they share rulings, but is that bond of bringing back still there? No. Bringing back requires, even within the iddah, what does it require in the talaq al-ba'in? Sorry?
A new nikah.
It requires a new nikah with its conditions. Witness, ijab, qabul, witnesses, mahar, etc. So that's if she was in a talaq raj'i. وإن أعتقت وهي مبتوتة. مبتوتة, what does مبتوتة mean? Yeah. Yeah. البت هو القطع. البت هو القطع. وهي مبتوتة. Just a note for those relying on Quduri through the Lubab is that the Lubab is arguably the best of the commentaries, but the Lubab does not focus on explaining everything in the method. Right? Right? For example, in a lot of commentaries and some of the, like the Indian, what they call the Sharh Dirasi, and the teaching Sharhs, those should not be ignored, okay, because they explain out the words. And in studying anything, one of the important things for a student is you need to know every word, because you're not studying the commentary. Okay? But you know, like a test would be, okay, what is mabtut? I don't know. What is bet? I don't know. If you don't know the method, doesn't mean you didn't study it, right? So this is why. Right? And this is where a commentary like the Jawhar al-Nayyara is very useful, right? Right? But even a commentary like the Jawhar al-Nayyara doesn't always explain all these things. That's why those commentaries can sometimes seem less intellectually satisfying. They're not giving the reasoning and the details and the fatwa, but they're there to clarify the method. So don't overlook them. Also, very often the authors of those texts compile them after years of teaching the text. So you find them in them, mafatih al-mughlaqat, like things that open, matters that are closed, that often you could look in 10 major commentaries on the text and you won't find the hal of a mushkila. Okay? Those are useful to have, like a couple of those texts around to clarify words, terminology, etc. as one goes through. Okay. So in a talaq bat, you know, like such as a talaq ba'in, for example, or mutawaffa anha zawjaha, or her husband had passed away, لم تنتقل عدتها, then her iddah does not transfer, right? Because here, this is not a state given to change, right? Because in a talaq ba'in or talaq upon death, the state of marriage cannot return. You know, in the case of talaq ba'in, i.e. without a new nikah, right? Now, then he says, and if this was a proper modern edition like the one I have, or you have, this would be a new paragraph, right? وإن كانت آيسة, if a woman is legally menopausal, فاعتدت بالشهور ثم رأت الدم انتقض ما مضى من عدتها وكان عليها أن تستأنف بالحيض. Okay? So if someone is legally menopausal, but so she was observing her waiting period on the basis of months, but then she sees blood, ثم رأت الدم, and this is الدم المعتاد, bleeding that is like her menstrual bleeding, right? And like seeing blood, the commentator adds, or if she becomes pregnant, right? So she thought she'd reached the age of legal menopause, but if she sees menstruation, then she's considered the what? Al-Hayd. She's of those who experience menstruation, so the asl for women is that their waiting period is 3 menstrual periods. So if, let's say, 2 months had passed, she has to go back and do 3 hayds. Because that's the asl. Why? That's what the divine command is regarding that, right? The verses on it. Or if she gets pregnant, that's added in the commentary. If she gets pregnant, then the sign is that she's not menopausal, right? أو حبلت من زوج آخر, right? Of course, how would that be? Like if someone died, if she got pregnant from another husband, for example. How would that happen? Can she get married to somebody soundly? You get married during? Right? No, because this is where you have to think about the text, right? And one of the things, is this connected to what came before or not? If a woman was آيسة فاعتدت بشهور, right? This mas'ala differs from the one before in something important. In the case of the woman, of the slave woman, if she gets freed in her iddah, that is conditioned by what? By the iddah still remaining. During her iddah, if she's divorced, so what happens? Her iddah was 2 months. Within the 2 months, she was freed. Then in the case of talaq al-raj'i, it extends to 3 months. So she's now a free woman. And the iddah is due upon her. But in the case of here, the ayisa, the woman who's legally menopausal, and we'll see what is the muftabihi for legal menopause, right? That this is not conditional by her still being in the iddah, right? So, وإن كانت المرأة آيسة فاعتدت بشهور, she did her iddah by months. So it's not just that she was still within her iddah, but the iddah finished, then she sees blood. What is due upon her is 3 menstrual periods, right? انتقض ما مضى من عدتها وفسد نكاحها, and her nikah becomes fasid. For the nikah to have been valid, her iddah needs to have been over. So the surah al-masala is not if it was within the hayd, within the iddah period, right? That if a woman was legally menopausal, let's say she's 62, let's say, and suddenly she started experiencing hayd, the iddah returns, she has to wait 3 menstrual periods. For this, and وكان عليها أن تستأنف العدة بالحيض, and she has to restart the iddah on the basis of hayd, right? And this is if she sees her blood regularly, right? And that's the relied upon position, right? As opposed to just some irregular discharge, right? But this, of course, causes some issues, right? So it causes some issues. And It's just theoretically sound. What is due on a woman? If she's divorced, iddah on the basis of menstruation. Why did we say that the one who's menopausal does not apply to? Out of necessity. What is necessity? That she doesn't get periods. So, but they say ما ثبت لضرورة زال بزوالها. Anything that is affirmed out of necessity is lifted when the necessity is lifted. And why did we switch from the asl, which is what is due upon her? 3 menstrual cycles. Why did we switch from that to months? Because she doesn't have menstrual cycles. And if she gets menstrual cycles back, then what was allowed out of necessity no longer counts. Right? That theoretically is sound and consistent. And he explains the reasoning from the Hidayah as well, right? But Imam Allama al-Maydani says further down, quoting right, that like Imam al-Marghinani, after explaining, says, Huwa sahih. Al-Marghinani says in the Hidayah, this is the sound opinion. Huwa sahih, right? But the Tasheeh, which is by Allama Qasim ibn Qutlubuha, he says that in other works, they said that the switching back to menstrual periods only applies if the iddah was not over. Because there's another consideration that comes up, right? Which is that there's a broad legal dabit, as-saqit la ya'ud. That something that is lifted no longer returns. So your iddah can either be over or not over. So if your iddah is over, khalas, it's over. Right? It's like, when can you make tayammum?
Absence of water, that one can use.
Yeah. يعني إن لم تجدوا ماء فتيمم, right? Like, if you don't find water, then you make tayammum, right? So it's عدم القدرة على استعمال الماء حقيقة, the inability to use water, actual or effective. So what happens if you make tayammum validly and within the prayer, Sidi Zayn announced, folks, found the water. What happens to your prayer?
Still good.
In your prayer, it's invalidated. Because your prayer is still not complete, and you found water, your prayer is invalidated. Right? Because it's one of the conditions of the validity of the prayer is sound purification. And what? And if you can use water, then you cannot resort to tayammum. But once the prayer is finished, you finish the prayer, Assalamu alaikum wa rahmatullah, Assalamu alaikum wa rahmatullah, and suddenly you see Zayn standing there with a bucket of water. He just arrived. You have to repeat your prayer? No. Because as-saqit la ya'ud. This is why I see Faraz used to argue at our university that friends don't let friends make ijtihad. So which principle governs here? That which is allowed out of necessity is not lifted except by it's lifting. So what is lifted when the necessity is lifted. Right? We only resorted to the months because the menstrual period was not allowed, or the fact that something that's lifted does not return. Okay? So here, the Allama Qasim in his تصحيح والترجيح لمسائل القدوري, he mentions that this fatwa is only given that the iddah is broken by months if she sees blood during the iddah. But if the iddah by months is complete, then after that, we don't say that she has to do a fresh new iddah, because that could be in position of hardship. Because that could be much later. Because the consequence of that would be, let's say a woman, her iddah was over, she got married, are we really going to say that that next nikah is invalid? What if she got pregnant from that other nikah? Right? So of course this would be one of the types of nikah fasid. But that would be imposition of many degrees of hardship. Right? So while theoretically sound, that opinion, we can't go into too much of the legal background because that's not the purpose of this class. So here, we may want to make a note here that that according to the method, right here, the Aysa, the one who does not experience menstruation, her iddah is by months, but if then she sees blood afterwards, the iddah by months is not considered, even if it was over. Rather, she has to redo her iddah based on periods. But the fatwa is that this applies within the iddah. Right? That when she's still within the iddah by months, if she sees menstruation, then she goes back to the iddah by months. But after the period is over, she has a fresh, then if her iddah is over, then she sees bleeding after that, it does not affect the validity of the iddah because it's over then. Okay? Because then the consequence of the nikah ending happens. That bond of marriage is gone. And once it's gone, it does not return. Right? And also there's consideration of preponderant risk, al-haraj madfu', hardship is lifted. But it's a subtle legal matter because it would appear, the former opinion is legally stronger from a certain sense, right? But fiqh also looks at practicality. Okay? And often the fuqaha will do things, will take positions that do not seem theoretically consistent. That's only because you don't get what they're doing, right? Because fiqh is not related to theory. Fiqh ultimately is the application of theory to the practical life, to practical situations in a principled manner. Right? So it is, Sheikh Adib referred to it. Sometimes the only, أحيانا يداوى بالسم. Sometimes one must treat with poison. This is harmful and that's harmful. This is less harmful. So it's, I'll tell you guys the context of that off camera. Too scandalous to put on camera. Okay. Then he tells us, وَالْمَنْكُوحَةُ نِكَاحًا فَاسِدًا. A woman who is married in a nikah fasid. Right? And if you have been reviewing, you would know what a nikah fasid is from the beginning of the text. What is the nikah al-fasid? Right? A nikah al-fasid, right, is a nikah that is missing, a nikah in which the rukun of the integral of the contract is found, but some of the conditions of validity, of soundness, are not fulfilled. Right? So the integral is an ijab and qabul. So there's an ijab, there's a qabul, actual or effective, but some of the conditions are missing. So we have the word witnesses, for example. Now, in terms of the moral ruling, the nikah al-fasid is like the nikah al-batil. It's sinful, morally. Legally, it's punishable. It's punishable, right? And it is obligatory, if discovered, it is obligatory for a nikah fasid to be, for there to be, there's criminal punishment for it, right? It's a discretionary criminal punishment, but it requires punishment. The definition of a nikah fasid, I don't want to go too much into, but this is sufficient that it's one where that some of the conditions of validity of shurut al-sihha, the conditions of soundness, are not met. But it's a little bit tricky. Why? Because the Hanafi fuqaha sometimes refer to the nikah al-batil as being fasid. Fasad al-nikah meaning batal. So it's it's a tricky thing to really pin down. Morally, it's not a marriage. The principal difference is that it has to do with iddah being required. Principal difference is iddah being required. So, and we'll share some texts relating to al-farq, the difference between the nikah al-sahih and nikah al-fasid, just to help. But al-mankuhatu nikahan fasida, a woman who is married with a unsound marriage, right? Al-madkhul biha, with the nikah being consummated, right? And just being alone together does not have this consequence, because it's not really a nikah. So they got married without witnesses, for example. Or there were witnesses, but one of them turns out to be atheist. Right? There's no way that you believe in that. Absolutely not. They only had two witnesses. Other people weren't around. وَالْمَوْطُوءَةُ بِشُبْهَةٍ, and someone who there's intercourse with shubha. A shubha includes the fact that there was payment. It looks like, right? عدتها الحيض. Right? Her iddah is hayd. Right? If she's of those who experience hayd, and al-ashhur by months if she is not of those who experience hayd. في الفرقة والموت, right? In separation and in death. Right? In separation, if she's separated, right, then her period starts, or if he dies, if the man dies. And this is in order for it to be known. Why is there iddah here? So to know that لبراءة طلب براءة الرحم, and to know that she's not pregnant with someone else's child. Because so there's like an iddah period, because after that no one else can marry her until that iddah period, to ensure that she's not already pregnant with somebody else. Right? And here, and the furqa here, fil furqa, is عقيبة, the way it's put in مجمع البحرين, the expression, he clarifies it, is عقيب الفرقة بينهما. عقيب الفرقة بينهما, after right, after they separate, right? After either they actually separate, right? So they've moved in together, for example. So they say, okay, I'm moving out, this is haram. And they actually separate, number one. أو العزم على ترك الوطء. أو العزم, or the resolve not to engage in intercourse again. Right? From Majma al-Bahrain. Right? Which in the case, for example, they hadn't moved in together, but they said, well, we got a secret nikah done. It was just ijab and qabul, for example. So it's nikah fasid. It's not a nikah. It's really, and that's it. Interestingly, of course, in al-ahwal if you look at Mukhasar al-ahwal al-shakhsiyya of al-Rabbani, he refers to it, and I believe Quduri does this in his matn of al-ahwal al-shakhsiyya, as النكاح غير الصحيح, the unsound, غير صحيح, just to, because fasid has, there's a number of complications is using the term fasid, but the fuqaha used it. You have to navigate around how they used it. Now, one of the reasons, and remind me to share this, if I don't, just task it to me in our last project. Ibn Nujaym has this beautiful quote, like, why do the fuqaha complicate things sometimes? Right? And this beautiful quote, Ibn Abdin quotes, قَصْدُهُم مِّنْ إِطْلَاقِ عِبَارَاتِهِم. They deliberately mention things in general ways sometimes, right? And لا يدعي علمهم من لم يزاحمهم عليه بالأخذ عن المشايخ بالقعود عند المشايخ that basically that so that people who are not taking this knowledge from its people not claim the knowledge themselves, right? Because it says nikah fasid, but do you know what it means? Right? Do you know what it means? No. Then, that's why علامة خالد علامة الأتاسي in Sharh al-Majalla, in one place he says فخذ هذا التحقيق ودع عنك ما قاله الشارح رستم باز فإنه يتمسك بالمباني ولا يدرك المعاني. Says, take this verification of the issue and leave aside what the commentator Rustum Baz said. And Rustum Baz, the Hanafi school is the only madhab where we have multiple Christian commentators on our books. Commentaries that were used. So the Majalla has, so Rustum Baz was Lebanese, has a respected commentary on the Majalla. I don't know if it's online. And he's Christian. And leave aside what Rustum Baz, the commentator Rustum Baz says, because he holds fast to the يتمسك بالمباني, he holds fast to to the forms, وَلَا يُدْرِكُ الْمَعَانِي. But he sometimes doesn't get the meanings. But what counts is the meaning, not the words only. Yes, it says that, but you know what it means? No. Right? So that's the challenge. Okay. So al-furqa here refers to where they decide to separate. Because furqa elsewhere is used to refer to tafriq al-qadi, for the qadi to separate between them. Right? Right? So this here could be the qadi separating between them. That's one case where it's raised, right? Someone reports this couple is here, but they don't appear to be married. So it goes to the qadi, so the qadi separates between them, right? Right? That's one case. But the other separation is, right, which he doesn't mention, al-furqa is not just, when does the period start? Al-furqa is either qada'an, when the matter is raised, and two people are living together through a nikah fasid. Does it count as a nikah? No. It's not morally a nikah. But it's called nikah fasid because it has some legal consequence. So the qadi separates between them. But like the qadi's separation is what if they repent to Allah subhanahu wa ta'ala? When does it begin then? Because the nikah fasid, is it an actual nikah? No, it's not. النكاح الفاسد كالباطل في عدم انعقاده. The nikah al-fasid is like the invalid nikah in that it didn't take place. It's called the nikah because it has some characteristics of the nikah, but it's not a nikah. And it has a key consequence of the nikah, which is the iddah, not because it was a nikah, but because of the hurmatil arham, right? Because the rahim is the basis of society, is the fact that we have clarity of family and lineage and so on, right? That's very critical. So there, the furqa could happen in court, but like the furqa is, because there's no, you cannot divorce, is أو العزم على ترك الوطن, or they decided not to engage in intercourse anymore. Right? وإذا مات مولى أم الولد عنها أو أعتقها فعدتها 3 حيض. Now the walad is a woman who gave birth to a child from her master. Okay? And this is one of the integrative means for, and something people get like they get emotional about. You have to be aware of people's emotions. And alhamdulillah, the institution of slavery is over, but if you look at the reality that human societies differ, and difference leads to conflict. Conflict leads to war. And when war takes place, amongst the most vulnerable people there are children and then women. The basis would be that they would have no rights, and they'd be raped, and it would be a free for all, right? And then what do you do? It'd be like use tissue paper. You just slaughter them after. Because what are you going to do with them now? They're a nuisance, or they have children, and the children are uncared for. Right here, and then they become rightless slaves. So here, this institution of al-Walad and Milk al-Yameen. And now we say this is over, but is it evil? No, it's not. Because you have to look at when to understand something, you can't just look at the micro level, but at the macro level. Right? That war is not a desirable state. Like, what do you do with a criminal? Now, first thing is, if in the ideal case, we don't have criminals. But if you have crime, what do you do with it? Imagine someone comes and said, there's human beings living in jail for years. Poor guys. Why do you do this to 1 or 2% of your societies? Okay? But there's a background to it, right? So it's not, some rulings are not related to the normal case or the ideal case, but they're to do with undesirable contingencies. The war happens, you've taken over a land, what happens to those people? So here, the Milk al-Yamin is regulated, but this integrates not only those women, but also their children into society. Because that the child born from a Milk al-Yamin relationship, what's the legal ruling of the child?
Free.
The child is free. Then what happens to the mother? The mother also gets free upon the death of the father. Right? But that integrates her children into society. Right? As opposed to being just considered a bastard son. Right? That there's a moral and legal, a high moral standard for the treatment not only of the Milk al-Yamin, but also of the children from that they have to be treated equitably, right? So that's a separate matter. So إذا مات مولى أم الولد, if the master of the al-Walad, of a slave woman who gave birth to a child from her master, he dies, أو أعتقها, or he freed her, which would commonly be done, because now your child is free, but the child's mother is a slave. They'd often free her, whether or not they married her, right? فعدتها 3 حيض. Then her iddah is 3 haids, right? If she still menstruates, or 3 months if she doesn't, right? Right? Because once he dies, she becomes free, right? So the moment the master dies, she becomes free and she enters into iddah. So what iddah does she enter into? The iddah of a free woman, basically. وإذا مات الصغير, if a child dies عن امرأته, if a child dies leaving behind a wife, وبها حبل, and she is pregnant, okay? And this is a confirmed pregnancy. And a confirmed pregnancy would be one that she delivers less than 6 months after his death. Now, if the child, it's unlikely that practically the children produce babies. No, but the general principle is given precedence over this, which is al-waladu lil-firash. The child is ascribed to the marriage. The firash is zawjiyya, right? It's almost impossible hadith. Okay? The child is for the bed. Like, what does that mean? Right? The firash here is firash zawjiyya. Right? The child is ascribed to the marriage. Right? Even when it seems to the contrary, right? There's cases where it happened during the time of the Prophet. Sahabi was away, child was born while he was away, he thought the child was not from him, but it was within possibility for it. If you remember, it was highly unlikely, and he suspected somebody, and he felt that the child later felt that the child resembled that person, but the Prophet said, the ruling of the al-walad al-firash applies. There's rahmah. Rahmah in it for the child. There's rahmah in it for the couple. Someone made a mistake. It's better. You know? Maybe. Right? That some truth is harmful. Some truth is harmful. Right? That's where rahmah is given precedence over justice. Because some kinds of justice, right? Like some justice, you know, they said that there's justice like this, right? Which is where the scales are balanced, and that is, you know, good justice. But the other justice which cuts, right? Right? And that kind of justice, like, beware. You could get it, but you'll get it. Like, it'll hurt you, right? So I want the truth. Seek mercy. And that's what rahmati tasbiqu ghadabi. The Prophet tells us that Allah subhanahu wa ta'ala affirms that my mercy outstrips my wrath. And the wrathful justice is harmful in these kinds of situations. Anyways, وإذا مات الصغير عن امرأته وبها حبل, and she is pregnant. Now this is unlikely, but this is a legally credible pregnancy, i.e. it's less that she delivers after his death, less than 6 months after his death. Right? So that could be, because the fuqaha said generally less than 6 months is not a likely pregnancy, right? Or if a child before that and they survive due to modern technology or whatever, then it's still ascribable. And in this case, things like, we would say do not get genetic testing, etc., etc. That's just, there's no, that's وسوسة. فعدتها أن تضع حملها. Her idda is that she delivered the child. Same general principle. فإن حدث الحمل بعد الموت فعدتها 4 أشهر. But if she becomes pregnant after the death, then her idda is 4 months and 10 days. 4 أشهر و10. Right? Because that would not be ascribed to could not even legally be ascribed to him, right? So وإذا طلق الرجل امرأته في حال الحيض وإذا طلق الرجل امرأته في حال الحيض. Now, if a man divorces his wife during hayd, now there's a presumption to this, which is at-talaq. What's the ruling of talaq during hayd? And we took this in the section of talaq. It's talaq al-bid'ah. It's sinful. It's prohibited. It's sinful. It requires tawbah. And in the general case, it would require taking her back, so that you don't cause her either. Okay? إذا طلق الرجل امرأته في حال الحيض. So what happens? He لم تعتد بالحيضة التي وقع فيها الطلاق. She does not perform عدة with the hayd during which the talaq took place. Why? Because her duty is to perform 3 full. Idda is 3 full hayds. Right? So even if there was some kind of indicator, okay, I've now entered hayd, so there's a haydometer that she uses that syncs to her app and is connected to her husband's phone, that your wife now is menstruating, says, okay, therefore you're divorced. Like, even at the moment, or he set up, using automation, when he got the hayd notification, immediately a message went to her on his behalf, you are not, or whatever. It was done immediately. Even at the beginning of the hayd, if he divorces her, that hayd does not count. So what happens then? So the hayd would start from the 3 iddah periods would start from the one after. وإذا وطئت المعتدة بشبهة فعليها عدة أخرى. Right? If there was a shubhat al-nikah, right? So we want definitions for next class of 3 things, right? And since we're coming to the end, towards the end of the section on marriage and divorce, it's very useful to have clarity on 3 things. What is the nikah al-sahih? Right? What is the nikah al-fasid? And what is shubhatul nikah? And what resembles a nikah? Right? So we should have definitions for each, and what are the conditions for each. And we'll share some of the resources related to this. Practically, it's very simple. Allah subhanahu wa ta'ala, udkhul al-buyuta min abwabiha, enter homes through their doors. And fiqh has doors. This is something, inshallah, of benefit, so do pay attention to it. Hanafi fiqh has some doors. If you want to know what is the relied upon position and what are the key conditions related to a matter, in ibadat, if you want to save yourself a lot of hassle, how do you enter the door of the fiqh of worship? You have to enter from one door, al-hadiyya al-ala'iyya. It's written for primary school students, but it summarizes the fatwa positions in the fiqh of worship with discernment, with its author. He's not just the son of Ibn Abdin, but is a very distinguished jurist, and sometimes in many issues, well, not many, reasonably large number of issues, he actually disagrees with his father. That's itself very useful. But you want to figure out, okay, what is the summary of what Ibn Abdin has to say about this? Look at what his son puts in the Hadiyya al-Ala'iyya. And then from there, you can go back to Hashid ibn Abdin, but you'll know it'll serve as a door into the details, so you don't get lost. Because sometimes those details can be scattered over the discussions related to the issue. That's in the fiqh of worship. In the fiqh of mu'amalat, of financial dealings, the door to fiqh al-mu'amalat is, a door is the majalla, majallatul ahkam al-adliya, which is the Ottoman Commercial Law Code, of which Alauddin Abidin, of course, was one of the committee. Then other great scholars, led by a great Ottoman scholar, Jawdat Basha, and others, Sheikh Amin, and others, Sheikh Amin Jundi from Sham as well. They're great fuqaha. And they made some interesting choices where they left the transmitted position of the madhab because of the circumstances of the age. So an applied door to the fiqh of mu'amalat is the majalla, and it has great works on it, which we can discuss some other time. We want to figure out, okay, what are the conditions related to this? It breaks it down in a very systematic way. What is a valid sale? It tells you very, very structured manner. A little wordy, you can easily summarize it. A more legalistic and terse door into the fiqh al-mu'amalat is Quduri Basha's work, Murshid al-Hayran, a guide to the bewildered, إلى معرفة أحوال الإنسان. And that really summarizes what, like the conclusion of Ibn Abdin and the other great mutaakhirin on the things, but it does not really leave them. Where the Majalla, on many things, it took positions. Where things were difficult to apply, it took brave positions. Right? Brave positions, but generally accepted. Right? It became the law of the land, right? Which is very significant. Right? In the Ottoman times, of course, it is not incumbent upon us now, but the fact that it was the law of the land, the fuqaha applied it for a period of time, it has its significance. But not everything in it is taken. There's no book in which everything is taken. Even no book of hadith. Allahumma salli ala sayyidina. So that's the door into fiqh al-mu'amalat. Right? There's two doors. The Majalla is easier and applied, more rigorous and comprehensive, but sticking to the transmitted rather than the applied positions. Quduri Basha's Murshid al-Hayran. In the fiqh of personal law, Quduri Basha codified the relied upon transmitted positions of the madhab on personal law, and it was also served as the basis of the personal law of Egypt, and then from Egypt of both Syria and Iraq, and influenced personal laws up and down many other countries, Jordan and from the North Africa, etc. Is his work الأحكام الشرعية في الأحوال الشخصية. This was like a codification, and it's precise and very, very clear, and it's also very useful, right? Because it gathers things together, right? And it serves as the door, right? The Majalla has many useful commentaries. Right? The Majalla has many useful commentaries. On commercial law. We'll just mention three just very quickly. There's Rustum Baz, which is very clear and concise. Even though he's Christian. So Sheikh Muhammad Jum'at did not like it at all. He said, I prefer Muslim any day. Okay? He was not a Muslim. As Sheikh Hadid, he says, the Mashayikh respect the work, and they've gone through it, and it's reliable, except where like any book, like or trustworthy. توثيق العلماء له لا لنفسه, right? Because the ulama confirmed it. Worthy of being reliable, but in any book, there's things in it you cannot just take at face value, even the most reliable books. And then there's a sharh of Sheikh Ali Haydar, who was a great Ottoman jurist, and the sharh of Al-Atasi. It's arguably the greatest legal commentary. Ali Haydar's one is a gem. The opening of each chapter, he has summaries of the key rulings and the key conditions. It's a treasure trove. Al-Atasi's sharh is delightful, underappreciated, brilliant. He has a whole slew of things where he corrects position of Ibn Abdin with great respect and reverence to him. But and there's others. There are other commentaries on the Mir'at supporting text, and a bunch of others. But the Majalla serves as a door into fiqh al-mu'amalat. الأحكام الشرعية في الأحوال الشخصية في قدري باشا into personal law. Okay? Marriage, divorce, related chapters. And there's a very clear explanatory commentary on it by Al-Abyani, which he wrote like a 3-volume lengthy commentary that has a modern edition by Dar es-Salaam out of Cairo. Slightly bloated, it's like 4 or 5 volumes, I think. But there's an abridgment of that in 1 volume called Mukhasar شرح الأحكام الشرعية في الأحوال الشخصية. His abridged commentary in 1 volume. That's very useful, especially if something just unclear. It's quite a useful reference. It gives all the background and so on. Of course, there's many other books, other modern books on personal law.
What's his name?
Al-Abyani. That serves as a door into fiqh al-mu'amalat. And those are the 3 biggest areas related to law. And we'll leave the discussion. The other part, the big, has to do with public law. We'll leave that till when we come to public law.
Could you mention a commentary from Murshid al-Hiram?
I believe there is a commentary on it. I haven't ever seen it in print. If you guys find it, I haven't looked for years though. For a while I was in a hunt for it. I came close, but never applied. If you do find it, God bless you. If you don't find it, God still bless you too. Okay. وإذا وطئت المعتدة بشبهة. Now someone who there's a shubhat in nikah, okay? Like someone paid for zina, for example. Yeah? Looks like a shubha of nikah, right? So technically, iddah is due from that intercourse. But then she engaged in intercourse again. So now it is due from the second one. So it keeps sort of pushing forward, right? Because the cause, which is the possibility of pregnancy, لاحتمال العلوق, right? Because they said the commentator said لتجدد السبب, because the cause is renewed. What's the cause? It's احتمال العلوق, the possibility of pregnancy is renewed. وتداخلت العدتان, and the 2 iddas, iddah from intercourse A and intercourse B, enter on each other. So what the hayd she experiences is ascribed to the 2 iddas. Okay? Because all we want to know is that she's not, that she's not pregnant, right? وإذا انقضت العدة الأولى لم تكمل ولم تكمل الثانية فإن عليها تمام العدة الثانية. Right? So she was in iddah from 1 shubhat nikah, and then there's another intercourse, another shubhat nikah. Then, so she has 2 or potentially multiple concurrent iddahs. So she remains in iddah requirement, and such individuals may well not enter into iddah. Right? Because if they did, they probably repent and not do it again. Right? So she must complete the second iddah. Right? And then he tells us, when does the iddah begin? Right? When does the time of iddah begin? وابتداء العدة في الطلاق عقيب الطلاق. The iddah begins with, in the case of talaq, when the talaq takes place. وفي الوفاة عقيب الوفاة. And the iddah of death from the time of death. Right? Why is it significant? The moment he dies, not after he's buried, etc. What if he dies and then a hayd starts? He died, oh my God, she goes to the washroom, cries, and notice that her hayd has begun, but they've not washed him, they've not buried him, they've not washed him, prayed over him, buried him, etc. None of that is the considerations, right? فإن لم تعلم بالطلاق. What if she didn't know that he divorced her? أو الوفاة, or his death. حتى مضت مدة العدة فقد انقضت عدتها. Then her iddah is over. That's why it is from the husband's duty to inform the wife without delay of being an iddah, that he's divorced her, unless there's an excuse. You can't choose to die, so you can't do much about that. But let's say they took a while to identify the body, etc. So it's from there. So let's say someone went mountain climbing, they disappeared. Turns out they've been dead, and they verified they've been dead from such and such a day. So her iddah begins from, not when he was found, from when he is legally considered, when he is reasonably considered to have died. So her iddah would not be from the time of discovery. Right? And there's fiqh related to that, we don't need to get into the detail, but possibility that people disappear, for example, right? It's from where we can either verify when they died or through reasonable surety. Okay. والعدة في النكاح الفاسد, right? And the iddah in the corrupt nikah عقيب التفريق is when they part بينهما أو العزم الواطئ على ترك وطئها, or when he resolves not to have intercourse. This is related to what we covered before, but I wanted to clarify it there, right? And when he resolves not to have intercourse and takes the means to leave, it's not just saying it and continuing, but he resolves, this is a genuine resolve. Al-azm bil-qalb. He says, okay, khalas, it's over, and it's genuine. It's not just, okay, we shouldn't be doing this. Right? So there is that. Right? And this is where intercourse is actually taking place, right? He mentioned in the commentary. Right? So the commentary says, وَهَذَا فِي الْمَدْخُولَةِ. This is in the one with whom intercourse took place. Right? أَمَّا غَيْرُهَا, as for other than the one with whom intercourse took place, يَكْفِ التَّفَرُّقْ بِالْأَبْدَانِ. Then they just have to part by their bodies. They don't have to, no court separation, or they don't have to decide. People got a bad egg, they went to a room at some center, and they said, I marry you, she says, I accept, come out there, oh, we just did a nikah fast, what do we do next? Said, separate, that's it, nothing else needed, right? But then an important point that, وَالْخَلْوَةُ فِي النِّكَاحِ الْفَاسِدِ لَا تُوجِبُ الْعِدَّةِ is from in the commentary. Being alone together in the nikah al-fasid does not require iddah. And there's no mafhoom to a talaq in the nikah fasid. Like someone pronounces talaq in a nikah fasid. These people got married in a talaq fasid. And then it's okay, we shouldn't have done this, I divorce you. But then 6 months later they got married. Does that talaq in the nikah fasid count? No, because they were not actually married. It's only considered called nikah fasid that there are some implications, which is the iddah. Right? The iddah. Right? Because this separation, whether done by the judge, separating between them, or their parting, is not a talaq. Right? Okay. And then, what are the implications? A woman enters into iddah, what does she have to do? And what does she have to do? That's what we'll look at in our next class, bismillah ta'ala, right? The rulings related to the iddah.